President Trump is on the verge of putting his stamp on the Supreme Court for the next generation. One area of the law that could be profoundly influenced is economic regulation. And we welcome now Ryan Radia. He's Research Fellow and Regulatory Counsel for the Competitive Enterprise Institute. That's a nonprofit organization advocating limited government and free enterprise. Ryan, welcome. Good to have you here.
Glad to be here.
As you look forward to a new Trump court, let's be frank, what it is, what do you look forward to with respect to economic regulation and the possible cutting back by the Supreme Court on what's been done in Washington?
So the regulatory state costs Americans, just at the federal level, over $1.9 trillion. There were 3,000 new rules issued in 2017, according to my colleague Wayne Cruz's analysis. The Supreme Court matters quite a bit in this realm because there are both current challenges in the courts and future challenges that businesses or other groups will bring to rules, whether it's rules from previous administrations being eliminated or new rules being issued by this or future administrations. And as these cases work their way to the Supreme Court, it matters because first the Supreme Court might look at individual regulations in a different way depending on the composition of the court, but there are also underlying legal doctrines that underpin the regulatory state that could be called into question by the court.
Well, and then that's part of my question, is the latter of those two, because of course you can challenge a regulation, goes up to the Supreme Court, potentially if they take it, they can decide whether to do it or not. This administration is clearly trying to deregulate. But what about going at the very structure of independent agencies? Is that on the table? Because we saw that, for example, with CFPB. We saw it with NLRB, the appointment, of members, with a pocket appointment, essentially. Do you see a potential fundamental shifting of the structure of regulation?
I do. You brought up the CFPB, the Bureau of Consumer Financial Protection. There's a case right now that could end up in the Supreme Court in the October term later this year involving a challenge from a bank in Texas to the structure of the Bureau, specifically whether its head can be removed by the president or without cause. Right now there are layers of insulation. Now that gets to really all independent agencies potentially, but especially ones that are headed by one person. The other issue, of course, is judicial deference to regulatory agencies. When an agency is interpreting a law that Congress has enacted, making a rule, the question is, do courts defer when it's not clear what the law means? For the last several decades, courts have said we will defer to the judgment of the agency. However, Justices Thomas and Gorsuch have indicated that they're skeptical of this doctrine. It's possible that with a new justice, we could see that doctrine revisited.
Do you envision a world where we don't have so-called independent regulatory agencies, that they're all subject to the political control of the president?
I do. To be sure, it's a long road before we get there, but we have three branches of government. They each have separate power. Executive is vested in the executive, legislative, and judicial. The independent agency is a creature that emerged in the New Deal era, which is really hard to fit with the framers' idea of what the Constitution means. We could see them revisited, where these multi-member agencies that are independent are curtailed in a way that makes them more accountable to the president.
Okay. Ryan, thank you so much for being here. Really good to get your perspective. That's Competitive Enterprise Institute Research Fellow and Regulatory Counsel Ryan Radia.